The Court of Appeals is now in session.
Good morning, all. Welcome again to Utah Court of Appeals, once again in virtual session, which we will be doing for the near future. We're in the process of retooling our courtroom to accommodate the reliable possibility of hybrid proceedings. We need screens, we need new sound, etc. And would you believe it? There have been supply chain issues and labor issues, and that did not come together as quickly as we had hoped that it might. So until further notice, we'll still be doing what is now seeming like the old-fashioned way. I think all counsel present have appeared one or more times during our virtual sessions, so I won't belabor the special rules applicable to that different procedure. I will just remind the group that because the judges can't look left and right and get a sense of who's going to be asking questions next, we're trying to get in the habit of raising our hand when we want to ask a question. So if counsel would be mindful of that and make a point to come to a prompt, convenient breaking point to take the question, we would appreciate that. You don't have to stop mid-sentence, but definitely stop at the end of that paragraph, as it were, so that you can take our question. As you all know, usually it's our questions that are the most important part of your argument anyway. Secondly, so that we can concentrate on the argument being made by the attorney at the virtual podium, we ask those counsel who are not then arguing to not only mute their microphone, but to stop their video so that we can concentrate on the attorney making the argument. As always, we allow 15 minutes aside for argument. If we run over a little bit because of the court's questions, that's fine, but we don't want counsel to expect that they can run over just because they have a few more points they'd like to make. And of course, we're very indulgent about the realities of internet failure and glitch and so forth. And if we find that a judge or an attorney has lost their connection and we need to rewind a little bit, we're absolutely happy to do that. That's why we're now setting our matters an hour apart rather than back to back, so we have a little wiggle room in that regard. Any questions about any of that? Very good. And I will ask counsel in the case of In Re BW to state their appearances for the record. And each time counsel comes to the podium, if they would remind us who they are, we would appreciate it. We won't have forgotten, but occasionally we like to go back, or we like to have our law clerks go back and listen to some of the argument. And it's helpful in that regard if we have a real-time reminder of who is saying what when. Go ahead then. Let's hear first from counsel for appellant.
Good morning, Your Honor. Sarah Frommer of the appellate group representing the mother whose rights were terminated, HW.
Martha Pierce for the minor children.
And John Peterson, Assistant Attorney General on behalf of the state of Utah.
Thank you all. Ms. Pierce and Mr. Peterson, we'll see you in a few minutes. And Ms. Frommer, we'll hear from you as soon as you're ready to make your argument.
Yes, I am, Your Honors. Again, Sarah Frommer representing the appellant. In a recent decision, the Utah Supreme Court in JAL said that when an order terminating parental rights is infected with legal error, the termination order needs to be reversed, and the juvenile court needs to go back and apply the correct standards and see if it perhaps will come to a different result. It is our position that the juvenile court in this case committed legal error with respect to two key issues in several different ways. The two key issues are, first, the way the juvenile court dealt with mother's drug use. And second, the way the juvenile court dealt with the issue of placing the children with the family member, specifically the maternal grandmother. With respect to the issue of the drug use, it is apparent from the record that from beginning to end, the court was of the view that any use of drugs disqualified the mother from being considered a fit parent. Yes, Your Honor.
Ms. Frommer, this a question with sort of global implications on this case. Does methamphetamine enjoy undeserved bad rap? It occurs to me that if we had before us a high-functioning alcoholic, and the evidence was that notwithstanding this drinking problem, she was a flawless parent. She binge drinked on the weekends when the kids were with their dad. She drank it up big time when at jazz games, then caught a ride home. The kids were in bed. Every morning she woke up sober. She never had a drink around them. It seems to me that we would be receptive to the argument that such a person was not necessarily an unfit parent. Is there such a thing as social meth use? And should we regard meth as being basically on the same footing? A person can go do meth on their own time, and so long as they're appropriate around their kids, it's just not that big of a deal.
Well, Your Honor, I'm wondering if you took a secret look at my argument outline, because that is pretty much exactly the argument that I intended to make with respect to meth use. Not so much that meth is the same as alcohol, or that it necessarily enjoys a bad reputation, because I don't think anybody's trying to argue that taking meth is a good thing, just like I don't think anybody would try to argue that binge drinking is a good thing. But I think the statute places them on the same footing. The statute says that the statute speaks to habitual excessive use of intoxicating liquors, which is your example, controlled substances, or dangerous drugs. Intoxicating liquors, controlled substances, or dangerous drugs are all included together in the statute that goes on to say, render the parent unable to care for the child. So, one moment. So the issue then becomes, rather than focus on whether it's meth or whether it's heroin or whether it's cocaine or whether it's alcohol, the question is, did the parent's use of it render the parent incapable of caring for the children? And the assumption with respect to meth or any dangerous drug or controlled substance is referred to in the statute, that it is per se results in the parent's inability to care for the children, is where I think the legal error comes in. Yes, Your Honor, Judge Tenney.
That leads to my question. Do you think that if there was evidence before a juvenile court, whether it be this case or some other case, that if a parent was addicted to meth, do you think that the juvenile court could use that addiction as grounds for terminating rights?
Not per se. Certainly the level of addiction and the extent to which addiction can mean different things. Addiction can mean, on the one hand, that they're lying on the floor with a syringe in their elbow, incapable of articulate thought. Addiction, on the other hand, can mean habitual use, meaning it could be occasional, but it's still habitual. And I think that the people who deal with drug addiction would still consider that addiction, but it doesn't necessarily mean that the person who is addicted cannot care for their child.
Well, let me come at it from a perhaps different angle. Would you agree that if a person is high on methamphetamine, their parenting instincts might be questionable? Do you think that's clear?
I think that if a person is attempting to care for a child while high on meth, their parenting instincts may be questionable.
Okay,
But I
so
don't
then,
think
so then, if there was evidence before a juvenile court that whether we call it addiction or we call it habitual or whether we call it some other label, do you think that if there's evidence in front of a juvenile court that a person keeps using methamphetamine even while they're supposed to be parenting, that might be grounds for termination?
it could, but I don't think there's any evidence in the record that this mother used methamphetamine while she was supposed to be parenting.
But is there reason in this record for the juvenile court to think that the mother's use patterns of methamphetamine were such that she was either unable or unwilling to stop using methamphetamine, even when told that she needed to at risk of losing her children?
It would be my contention, Your Honor, that the evidence in this case indicates exactly the opposite. The evidence indicates that her use, she testified that her use was sporadic. The evidence in the record is consistent with that. Admittedly, she tested positive and the umbilical cord of the twins tested positive at the time she gave birth. That is indisputable, that happened. But they both tested clean a week later, indicating that there was no prolonged exposure to methamphetamine that would have resulted, or continuous exposure that would have resulted in a longer exposure. Also, I see Judge Harris, your hand. Let me finish the sentence. I'll get to you. And the other thing is that the evidence shows that she tested clean, positive, clean, positive, which is indication of intermittent use, not continual use. It's not like she tested positive at every single test. She remained clean for 3 consecutive months at the beginning of 2021 and did not even get the consideration of an overnight visit with her children, which is the indication that this court, whatever in some hypothetical situation where there was actual evidence that methamphetamine use interfered with the parenting ability, this court took a zero tolerance approach. And that was a legal mistake. It is our contention. Yes, Judge Harris.
Yeah, my question is this. The juvenile court found several different grounds for termination. We've been talking about unfitness and I guess obliquely about abuse and neglect through the lens of harm. But what about failure of parental adjustment? I mean, the state makes, I think, an interesting point where the state says this is a textbook example of failure of parental adjustment and or failure to remedy the circumstances of removal. Can you respond to that in particular?
Yes, I can, Your Honor, because that goes back to this same point. What constitutes remedying the circumstances that led to the removal? If you take the approach that any use of a dangerous drug is disqualifying, then any use of the dangerous drug would be failure of parental adjustment. But if you take the position, which is our position, that the statute specifically contemplates use that renders the parent incapable of caring for the child, there is no evidence that she did fail to remedy that. There is no evidence that she is unable to care for her children. And in fact, she made significant effort to overcome her addiction. And the fact that she didn't 100% succeed in being 100% clean should not result in the conclusion that she wasn't trying or that she wasn't able to care for her children or that she failed to remedy the circumstances. Yes, Your Honor, Judge Kenny.
Let me jump in there. I'm not totally sure that I read the juvenile court's order quite as broadly as you do. I mean, you use phrases like 100% and failure to make any efforts and so forth. But as I read the juvenile court's order, what he seems to be really keyed in on, at least in my reading of it, was that after she had gone to the inpatient treatment center, and then she came out of the treatment center, then she still had a number of meth uses after. I mean, looking at page 1063 of the order, Judge Ross enters a finding that she missed drug tests on September 2nd and 3rd, 2021, that she tests positive for meth on September 8th, 2021. And then I think the next sentence of his order is really critical. He says at trial, quote, mother testified that she had 3 relapses and 5 meth uses in the short 2 months time from leaving treatment to the date of trial. So I don't read him as saying that if she relapses a single time, he's going to find her grounds for termination. He's saying, look, we had gone through this several month, even over a course of a year process of trying to get her clean. She goes to a several month treatment. She comes out. she keeps using meth at that point. And if the statutory ground is unwilling or unable, either one of two things seems to be true at that point. After having gotten inpatient treatment, if she keeps using that, either means that she's addicted and can't stop, or it means she's not addicted but is unwilling to stop. And either way, there's grounds. What's wrong with that viewpoint from the juvenile court?
I think what's wrong with that viewpoint is that there is no evidence that somebody who has gone through rehab and then has a lapse is suddenly back into, full-blown addictive status. And I think especially in a case like this, I mean, consider the overall circumstances. She's trying to get her children back. She does everything the state asks her to do. At the beginning of 2021, she remains clean for 3 months. And what do they say to her? Not good enough. Even after they terminate reunification services, she goes into rehab and she gets high marks from the rehab center. And she comes out and she actually believes at the end of this, now maybe she has a chance at getting her kids back. And they say, no, we're going forward with the termination proceeding.
Right, but isn't the response at that point no? Because even having gone through inpatient treatment, you're still using meth repeatedly within weeks of coming out. I think that's what their response is. Why is that the wrong response?
Because I question that the evidence shows that she was still using meth repeatedly, or that Justice Harris spoke earlier that to the issue of harm, or that her use of meth harmed the children. And harm does not mean bad idea. Harm has a very specific statutory definition that includes physical or developmental injury or damage, emotional damage that results in serious impairment in the child's growth, development, behavior, or psychological functioning, sexual abuse, or sexual exploitation. And there's no evidence that any of those elements of harm exist in this case. If I may, Your Honors, I see my time is up, but I would like to turn to the question of the family placement for a few moments, if I may.
You may, and I'll give you a couple minutes because you spent a lot of time answering our questions. But if you move beyond 2 minutes, that will be coming out of your rebuttal time.
Okay, fair enough, Your Honor. Because the issue of the family placement also goes to the issue of whether mother is capable and is able to take care of the children, because it is our position that had the grandmother been allowed to be the guardian, or even to do some sort of co-guardian arrangement together with the mother, where the grandmother was overseeing and being responsible and keeping the mother on the straight and narrow with respect to the children, had that been permitted, we might have a very different outcome. And yet, the state has taken very binary approach to this. Either the mother can get the kids back, or they have to be adopted, or they have to be placed in some guardianship. And the grandmother isn't an acceptable guardian because the step grandfather couldn't pass the background test.
I'm not sure how you divorce step grandfather from the equation, even as you formulated it. If grandmother is living with step grandfather, even at least part of the time, and if it's true that his inclusion on that list, the LIS list, makes them something of a danger, then don't you have to consider grandfather?
Well, yes, but the question, Your Honor, and the important question, the $64,000 question is, does whatever put grandfather on that list 15 years ago or 20 years ago make him a present danger to these children? And since we don't even know what it is, we have no way of knowing. And the inquiry is, can the children safely be placed with grandmother? Not, can grandfather be licensed as a foster parent?
But we know the kinds of things that it would have to have been for him to get on the list. I mean, you're right, we don't know the particulars, but we do have a statute that sets forth the 7 categories. We know the kinds of things statutorily that qualify under the 7 categories. So we know it's one of those things, right?
Yeah, suppose the one thing was that he had, suppose the one thing that as a 30-year-old man, he had sex with a 16-year-old girl. And that was the thing that kept that created the problem. Also, what do we know about this? First of all, we know it happened a long time ago. Second of all, we don't know what it was. But third of all, we know that there were 5 incidences reported and 3 of them were overturned. And fourth of all, we know that there was never any criminal report or criminal conviction. But again, we have no idea of whether what grandfather did 15 years ago has any impact on the safety of the children now, especially given the fact that the step grandfather isn't even home 6 days out of 7. And given
But he is home 1 day out of 7. And so, I mean, you can just see the headlines being written that if a juvenile court had placed the child in a home in which there was, say, a pedophile 1 day out of 7, I think most people would look askew at that, right?
if he was a pedophile, we don't.
And I know that's not the fact. I know that's not the fact here. Just so nobody misinterprets that. That was meant as a hypo. But the fact, what I'm pushing back on is the idea that him being there 1 day out of 7 is nothing to be worried about. If it's true, this is my question. If it's true that he is in fact a danger because of this past incident, I'm not sure why the fact that he's only there 1 day a week means that we shouldn't be worried about it, or we shouldn't let the juvenile court be worried about it. That's my point.
I'm not arguing that it's nothing to worry about. I'm arguing that there's no evidence in the record that it was in fact a problem. Clearly, the reason the statute, not even I am advocating for just handing the children over to the grandmother without the inquiry that is required by the statute. But the inquiry that's required by the statute is designed to flush out potential concerns. It's not designed to disqualify. And so you look into it, this flushes out the concerns, and then you need to say, all right, well, what is this? What was the problem then? Is it still a problem now? Has there been rehabilitation? Can it be addressed with a safety plan? But none of that inquiry was made. They just said, no, even though the grandmother would have been a wonderful placement for these children, and the children had been involved in the grandmother had been involved in the children's life. They didn't even push back.
Let me push back a little bit, Ms. Frommer, on
Yes.
whether you said the inquiry was never made. There was an administrative inquiry into this, right? I mean, you mentioned it yourself. The step-grandfather did challenge this administratively and was successful in getting the administrative folks to agree that 3 of the 5 issues on the list were no longer of concern. But there's a contemporaneous determination administratively that 2 of them are still a matter of concern, and that they have to do with sexual abuse of children. Now, you're right, we don't know the particulars any more than that. But isn't that administrative process something that deserves some respect here? I mean, step-grandfather had his chance somewhere else to go and litigate whether this was still something that people needed to be concerned about. Number one, isn't there a danger if we do what you're asking in turning these juvenile court termination trials into sort of mini trials on what step-grandfather did 20 or 30 years ago? And secondly, you're asking us to say that, we can overturn a juvenile court's decision not to place somebody with a household where somebody in the household has something on the list, and that's I guess put yourself in the shoes of the juvenile court. You're saying I'm not going to put the children in a household like that. So anyway, can you address the administrative avenue and then sort of the
Yes.
standard of review question?
Yeah. First of all, Your Honor, the LIS system is a system that you look at and say that's used for a number of purposes, including, for example, can this person be licensed as a foster parent? And it may well be that 2 of those incidents should not be removed for those broad purposes, because once the record is clean and there's nothing on the record, then there's no impediment whatsoever to placing the child with the grandfather, 24/7. And perhaps and since we don't know what it is, I can't speak to it specifically, but maybe it's something that could, in another circumstance, or maybe even this circumstance, we don't know, create a safety concern. But the notion that in and of itself it is disqualifying, I think, is disturbing, because what you're saying is what in order to, if you support this ruling, you're saying that notwithstanding the fact that the grandmother has been involved in this children's life, notwithstanding the fact that not being placed with them was significantly destructive of their relationship with both the grandmother and the mother, notwithstanding the fact that whatever happened with grandfather, however awful it was, happened a long time ago, notwithstanding the fact that he's rarely in the house, that there was no consideration ever made whether, notwithstanding whatever the finding is, can the children still be placed safely with the grandmother? Again, as I said before, not even I am arguing, oh, pay no attention to that LIS report, beyond the curtain. I'm saying pay attention to it, figure out what it is, what exactly was involved, and whether it in fact creates a safety issue for the current situation, instead of just assuming that because there's something bad on the record, the entire literally baby is thrown out with the bathwater. That's what we're arguing, that the state is required to prove by clear and convincing evidence that guardianship is not a viable option. And to just say, well, something bad happened a long time ago with somebody who's only even in the house 1 out of every 7 days, it's not clear and convincing evidence of the inappropriateness of that placement. That's in a nutshell our argument, Your Honor. And I see I've gone beyond my 2 minutes, Judge Orm.
Gone well beyond your 2 minutes. However, in fairness, the whole time you were beyond your 2 minutes, you were responding first to the questions of Judge Tenney and then to the question of Judge Harris. So we'll give you your 3 minutes on rebuttal, and we'll hear from the state and the guardian in whichever order they have determined is appropriate.
Great. Thank you, Your Honor. I'll see you in a few moments.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor children. Ms. Frommer is arguing a case that didn't happen. She's suggesting that the whole case rises or falls on whether or not mother's testing was negative or positive. And that's ignoring the record. And she's suggesting this is a legal argument, but really this is a sufficiency of evidence claim. Yes.
Can I be the judge that hijacks your argument? Can we start where we left off with the kinship issue, just since that's fresh on everyone's mind? Let me ask you the sort of flip side of the question that I was asking Ms. Frommer on that. There's something a little curious here, that we would have a best interest determination that would hinge in part on the juvenile court's concerns about the kinship, without any evidence on the record about what it was that happened with step-grandfather specifically, other than the fact that he's still on the list. We don't know anything at all. So how is the juvenile court supposed to conduct a meaningful best interest determination without knowing those details? And then concomitantly, how are we, the appellate court, supposed to review that determination without knowing those details either?
Well, the better question, I think, is whether or not the juvenile court or even this court can override the legislature, which says you can't license in these instances. And that's in the Utah State Code, and that's also in ASFA, that there's certain cases where you can't license, and you can litigate that at the administrative level, but beyond that, you can't. So she's actually asking this court and the juvenile court to rewrite the law.
Is licensing the same thing as kinship? Because I suspect that Ms. Frommer right now is writing in her notes, no, they're not the same thing. Because she had used a word, I think pointedly, that this is about foster situations, which seems different than kinship placement termination. Is that wrong or is that right?
Well, excuse me, you can't license, but there's also a place in the juvenile court, and it's in my brief, and I'll send in a 24J letter if you would like, that says the court shall not place. So it does go to placement. And also, I think when you're looking at this case, you also have to look at the fact that the kids have been here for 2 years. So that is a huge part of this as well. You don't want to change the continuity of care, and best interest is from the children's point of view. And from their point of view, if you could ask them, they would say, this is my mom, this is my dad, this is my house, this is my bedroom. From their point of view, they are home. This is their home. And that's highly significant. This case is not just about mother's rights. It's also about the children's rights. And the NRA KC case 215 Utah 92 says that children have a right to permanency and stability. And so from their point of view, they are home. Yeah.
But coming back to the kinship component of it, the statute does say that a court shall consider the kinship component of this. And not to just keep beating this drum a little bit, but I'm going to take the hypothetical that Ms. Frommer gave us and make it a little bit more extreme. Suppose that what actually happened with a person in step-grandfather's shoes is that as an 18-year-old, he had sex with a 15-year-old. And suppose that it happened 10 years earlier, 15 years earlier. If that's the basis for him being on the LIS, I think that somebody in the juvenile court shoes or in our shoes could look at that and say, no, that's not really reason to keep the kids away from kinship. But if we don't know those circumstances, then we're kind of judging the whole thing blind. That's why I'm a little bit troubled by the notion that we don't have those details on the record because we don't know what we're supposed to be evaluating. Respond to that if you could. That's like a 3-part question. But
Yes, I'm having a hard time knowing where to begin. But it sounds like you're saying if there's a circumstances where it seems like it's unfair or it seems like it's really not connected to care for a child, again, that seems like a legislative policy issue because the legislature pretty set forth pretty clearly what is and is not appropriate. And there's some places where you can fudge, I don't want to say fudge it, but where you can weigh the different factors. And there's some places where you cannot. And so it's one of those you cannot. That's a legislative function and not a function of this court. So even if we perceive it unfair or this court perceives it unfair, that's not within the judicial purview. So that's how. And
Ms. Farmer, I think you're not muted. I think that's part of the audio reason we're having. Sorry, just to throw in a technical thing. Ms. Farmer, my screen is showing that you're not muted. Thank you.
So if we're done with the kinship part, then, and also placing with kin doesn't preclude termination. A kin might be a very good placement, but there still might be a really good reason to terminate parental rights here. Now, this case didn't rise and fall. The evidence wasn't solely based on dirty drug tests. And this is also a case where the judge lived with the facts for a period of years. And there was much more than just dirty drug testing. In fact, all the rave reviews that mother received were in the context of supervised visitation. And when the caseworker was asked, how was she during visitation? The caseworker's response was interesting because she said, well, once we got her there, then she pretty much was appropriate. And you got to remember, the caseworkers are pretty much paid to praise parents for the baby steps that they are taking. And even then, in my brief, I outlined a lot of experiences where mother wasn't appropriate during visitation. And I also outlined all the other issues that were going on with mother, such as her inconsistency, the domestic violence. So the case is much more, this is not a high-functioning methamphetamine addict. We're not talking about that. That is not the case at all. And I think, and so this isn't a legal argument that Ms. Farmer is making, even though she frames it that way. It's a sufficiency of evidence claim. And as such, she needs to deal with the evidence that the juvenile court relied on. This isn't a closing argument. We have to give weight to the juvenile court and respect to the juvenile court as the trier of fact, as the one who weighs the facts, weighs the credibility, demeanor, all of that. And she doesn't do that. She wants to re-argue her case in a light favorable to her position. And that doesn't work at the appellate level. That's what you do at the trial level. So yeah, but again, from the point of view of the children, and that's what strictly necessary is, these kids have a home, they have parents. This is where they belong. And to ask that these little kids be disrupted after 2 years frankly, it's an outrage. And to ask that these kids be placed in the care of a mother who can't even be trusted to have unsupervised visitation, with the assistance of a grandmother who's with the grandfather who the state of Utah says we can't trust, that's an outrage as well. So the children also have a right to stability, consistency, and a permanent home. And I would ask this court to respect that. Yes, Judge Tenney.
Yeah, before you sit down, virtually, can you respond to the argument that we started with regarding methamphetamine use that as I understood Ms. Farmer's point, it was that if the evidence shows that mother is using methamphetamine, but not while supervising the children, then there's no evidence that her use is harming them. What's your response to that?
My argument is that her premise is wrong. This isn't a high functioning methamphetamine addict, and her rights weren't terminated solely because of her involvement with methamphetamine. The evidence shows that she couldn't show up to a visit. The evidence shows that she was in a domestic violence relationship. The evidence shows that even when she was being supervised, she couldn't act in the best interest of the children. So the premise is just all wrong that we have here a high functioning methamphetamine addict. Again, that illustrates that really, even though she frames this as a legal error, there really is a sufficiency of evidence claim, and we don't have that. And so we need to respect the trial court's judgment, who lived with this case and who went through the live evidence and who made very detailed findings. And so I would ask this court to respect those findings and to respect the needs of these young children and to allow them to be in the place where they think they are home. So if there's no other questions, I'm going to thank you for your time.
Thank you, Ms. Pierce. We'll hear from the state.
May it please the court, John Peterson on behalf of the state of Utah. I'd like to start off with just talking about the kinship issue. I think there's been a lot of, essentially the appellant's arguments are that this is some kind of Kafkaesque star chamber procedure where no one has any idea what was going on, and that's simply not true. The grandfather knows exactly what this case was. This was a case where DCFS removed his children from his home. And it was a successful communication. They were returned, but that's clear from the grandmother's proffered testimony at 614 in the transcript of the trial. There was a prior DCFS case where his kids were removed based on neglect and sexual abuse. So, I mean, so we can't sit around and pretend like we don't know what's going on here.
Yeah, and on that point, I have a question about sort of evidentiary burdens and proof here. I mean, DCFS, I presume, knows what's going on because they defended the administrative proceedings, right?
Yes.
And step-grandfather knows what's going on because he was the subject of whatever happened. And so DCFS comes in and says, look, we've got this problem with the LIS list. And at that point, DCFS is saying, because of this, we don't think this is an appropriate placement. If mother, grandmother, and step-grandfather think that, oh, it was no big deal, don't they have an opportunity at that point to put on evidence of what it was and make the argument that there was, this was all really nothing to see here? And to the extent that we don't have information in the record about this, who should sort of bear the blame for that, I guess is my question.
Well, I mean, I think grandfather did have it. I mean, it wasn't in the juvenile court, but there's an administrative, procedure system. There's also an expungement statute that hasn't really discussed in the briefs, but there's a couple of different avenues for, and I think the juvenile court reasonably, took the tact like, well, you go with DCFS and you try and work this out. And to some extent, he was successful. He had 3 of 5 removed, but there's still 2 after. And I think, the juvenile court reasonably relied upon it. There's a little procedural anomaly here in that the judge who was the original presiding judge over this at that time was not the judge who presided over the termination trial. And you'll see when the judge at the termination trial renders his ruling, basically this issue kind of resurfaced in closing arguments to the termination trial. And his response was basically, my predecessor and DCFS dealt with this, a ruling was made, and I'm not going to go back and revisit that ruling now. I wasn't there. Somewhat water in the bridge, not to make, light of it, but
isn't that a little bit problematic though, on some level? I mean, it's almost like he's outsourcing a key part of the best interest determination to somebody else, but he's the one that ultimately has to make it at that moment. So if he doesn't know the underlying details, how can he properly make that decision?
I guess I said, as I can't remember which if you noticed it, but the LIS, there isn't anything non-serious on the LIS. In this case, having your children removed, that's pretty serious. We're looking at this, surrogate care from the parents, and the people who we're looking at aren't really all that great anyway. Judge Orm.
When this administrative review is undertaken, as it apparently was here by DCFS, and then you say of the 5, 3 were removed, 2 remained. As with any other administrative proceeding, is there then an opportunity for judicial review if, in this case, the step-grandfather is dissatisfied with that result?
Yes, and actually what happened there's different stages. What happened here is DCFS has an internal sort of informal review, which he requested. And according to that informal review, they reviewed and said, yeah, 3 of those we can get rid of, but 2, no, we're going to keep those. At that point, he has the option to, file a petition in juvenile court, to challenge those inclusions. He didn't do that. So he did not, there was a procedure he could have followed, which he didn't. And if he had done that and lost, he could have also then taken that up to the Court of Appeals, this court afterwards again. But again, there was a procedure which he did not elect to avail himself of. And so I don't think it's unreasonable that juvenile court accepted.
Yeah, I'm glad I asked the question, and I'm glad that's the response, because I found myself sharing the discomfort of my colleagues that, well, if a judge can't look at this, how do we know that a terrible, horrible mistake wasn't made? How dare the trial court judge just defer so blindly to the apparent result of this administrative procedure? That strikes me, at least, as being much more reasonable if that judge can say, well, if he was dissatisfied with getting rid of the 3 only and not the other 2, he had his remedy. And if he chose not to pursue it, then it's quite appropriate for me to take that as, I mean, it's not res judicata, but it's appropriate for me to take that as a done deal. If he had if he had a more appropriate avenue for judicial review and opted not to take it.
Yes. And I guess I see. Oh, yes, Judge Kenny.
Sorry, I wanted your response to that thought and kind of follow up on that.
Do I have that right? I mean, is that basically the way, in your view, Mr. Peterson, that we ought to be looking at what the judge did here? He wasn't just dropping the ball and declining to look at it. He took the administrative decision at face value because the person aggrieved chose not to pursue additional administrative and judicial review remedies that he had.
I think that's entirely correct, Judge Arm. I 100% agree with that. I mean, there was, and rather than having a bunch of little mini trials here with every relative who might pop up, there is a procedure, and he allowed that procedure to bail out. And once the grandfather decided he wasn't going any farther, I mean, it was essentially that was decided.
Okay, so that's the jump off place then for my question. As I understand it, the question though before at that earlier stage is, does he still stay on the list? And what the administrative agency says is we're going to take him off with respect to 3 of the 5, but we're going to keep him on with respect to 2 of the 5. But then I think that begs then the question here, which I think is a slightly different question, which is we still have to do a best interest analysis in this case. And that gets back to the question that I started with Ms. Pierce on, which is, as I understand the LIS statute, you can be on that list for something such as an 18-year-old having sex with a 15-year-old. And suppose that had happened 10 years earlier. If those were the circumstances, and if he's still on the list because of circumstances like those, how can the juvenile court make the best interest determination here? And then how can we review that if we don't know that those are the circumstances that put him on the list?
Well, I mean, that's it. Yeah, I'd say, I mean, that's an interesting hypothetical, but those aren't the facts. He wasn't put on for indiscriminate sex with his teenage girlfriend. He was on the list because his children were removed by DCFS for bad parenting.
And we know that on this record. I'm sorry, I missed that. That's not in my notes.
That's the grandmother's proffered testimony at 614 of the record. She says she knew her husband had an open case, but it was a successful unification. I mean, and I think there's also evidence that grandmother doesn't really know a lot about what's going on with mom. You look at 611 on the record. She says she's never saw Mahar and the kids, but she doesn't know much about when he moved in with father. And I also, at footnote 6 of my brief, the caseworker the mother reported to the caseworker that she was worried because grandfather's son just got out of prison and was calling them up and wanting to come over and do drugs with them. So, I mean, there's some red flags here. This is not just like a hypothetical, something maybe kind of bad might have happened before. There's some red flags in these people's history. And if you'd indulge me, I would just briefly like to address the methamphetamine issue, which we started out with. And again, I think that's
take just a minute or so, Mr. Peterson, with that. I think we very well understand the state's position on that, but you can take a minute or two.
Yeah, I mean, I would just note that basically it's a case that originated, as I believe Judge Harris noted, with the children, the twins testing positive to have methamphetamine in their umbilical cord. This adjudicated. Everybody agreed that the parents had a problem. They have a meth problem. Mom has a meth problem that needs to be treated. She agreed that I'm going to engage in treatment. I'm going to get better. Did she? No. She kept using methamphetamine. She kept using methamphetamine when she was pregnant with AW, who's not subject to this. But again, it's very like she does not have any control over it. She's 3 out of 4 of her children. She used drugs during her pregnancy, even under threat of being incarcerated for contempt, losing her children. She can't stop. This is a textbook failure parental adjustment and or failure remedy circumstances. Nothing changed since the children were removed from her. She continues to use methamphetamine and she can't stop. She's an addict, and that does affect her parenting.
Thank you, Mr. Peterson. We appreciate the argument. Ms. Fromer, 3 minutes for rebuttal.
There I am. Okay, thank you, Your Honor. I'd like to address the arguments that were made by the guardian ad litem in the state. I'd like to start off with an easy one, which was Ms. Pierce's argument that the judge was involved for years and had been involved all along. In fact, in this case, the judge who entered the termination order was Judge Ross. He was appointed to the juvenile court in May of 2021, just after reunification services had been terminated and just shortly before the termination hearing. So this is not a case where the judge that entered the termination order was one that had been involved all along. And in fact, Judge Ross is in the same position as this court is he has to rely on the record and whatever is or isn't there. Secondly, I would like to take issue with Ms. Pierce's argument that this is a legislative issue and the court would have to overturn the legislature's intent with respect to placement. That's not our argument at all. And I laughed when Judge Tenney said, Ms. Fromer is scribbling notes right now because that's in fact what I was doing. We're not talking about licensing. Nothing in the statute that talks about kinship placement requires that relative be qualified to be licensed.
But let me push back on that. If the legislature has said definitively that if you've done one of these 7 things that puts on the LIS, we the legislature don't think that you're fit to be a foster parent, then why couldn't a juvenile court look at that and say, well, if the legislature thinks you can't even be a foster parent, then I don't have to send you there for a guardianship of some sort? Why is that wrong?
Because, Your Honor, you can't, the way you phrase it, you can't even be a foster parent. Being a foster parent is a much broader authorization than being a kinship placement for a specific child. Let's go back to the example that you and I have been talking about. What he did wrong was that he had sex with as an adult had sex with an underage girl. If everything were removed from his record, if that was it, and everything was removed from his record, and now he could be licensed as a foster parent, that would mean he would be qualified to be a foster parent for a 16-year-old girl, which might be completely inappropriate. But the thing that happened might have nothing to do with the safety of the placement of these children with the grandmother. Yes, Your Honor, Judge Harris.
Let me ask the same question to you that I put to Mr. Peterson. That is, whose evidentiary issue is this, right? DCFS comes and they tell the juvenile court judge that, hey, we've got a problem with the LIS list. We've got they had their administrative day in administrative court and they lost, and they've still got 2 things on the list, and we consider that to us, that's a deal breaker. Yeah. If your side thinks that it's not a deal breaker on these particular facts, in other words, if your side thinks that we have the metaphorical equivalent of an 18-year-old and a 15-year-old having teenage sex, isn't it incumbent on you to then tell the juvenile court, this is what we have going on here. You need to know, court, that what we have going on here isn't what you think it is, and you can call step-grandfather to the stand and you can put all this evidence in and ask the court to consider it. So to the extent we have an evidentiary lacuna here, why isn't that on you?
Well, I think the record shows that the step-grandfather said, because this happened very long time ago, he didn't know what it was. He didn't know what it was. Now, do we believe that or not believe it? Judge Mr. Peterson read from you the record where the grandmother says she doesn't know. The attorney for the state says they don't know. So in the absence of anybody knowing for sure what happened, the issue is then who is it most effectively knowable by? And clearly the state has all the records, so they're the ones who have the records of what it was. But more importantly, we're talking about issues of constitutional importance, and the statute is quite clear that this, and the case law as well, that the state has the burden to prove by clear and convincing evidence every element, which means that the best interest test must also be proved by clear and convincing evidence. And there is not clear and convincing evidence on this record that placing the children with the grandmother was in fact a safety issue. And the statute, I think, with respect to kinship placement makes it clear that it's a safety issue. Now, Ms. Pierce talks eloquently about the children and their placement in their home, and this is their home, but the statute makes it perfectly clear. And multiple studies have shown that children do best when they are allowed to remain with their natural family, and they are best served by being in a family situation with their natural parents and their natural family, including grandparents and extended family, if that is possible. So with that I would go so far as to call it a statutory presumption that the best interests of the child are best served by allowing the child to remain with the natural family. The state has the burden of proving by clear and convincing evidence that it's not true in this case. And I'd like to close by just adding one more point. Consistently throughout this case, the court refused to even consider a family placement, an overnight placement, any kind of temporary placement with the mother. So we have no evidence as to how the mother would have done if they had allowed that. In fact, Ms. Pierce talks about the caseworkers being unhappy with the mother's interaction with the children. The evidence doesn't support that. The evidence shows that both of the caseworkers thought that mother was a terrific parent, but for the issue with respect to the drugs. So for the guardian ad litem to try to say, well, this was about all kinds of other things, when the two DCFS caseworkers both said, no, it's about the drugs, I think is disingenuous on her part. But my final, I would like to close with this point. If a juvenile court orders the reunification and orders that the child be allowed, that the mother and the grandmother together be allowed to parent this child, and it turns out to be a bad idea, then the state can always file another petition for termination based on the new facts. And if that would happen, as in one of the cases, I forget which one, I think it was in Reed DV, where the court allowed the children to go back, and then there was a problem 2 years later, and in the second termination proceeding, the termination order was entered. At that point, there's really no leg to stand on. Right, you really had your chance and you blew it, and so. But
the problem there is now you're several years further down the road, and the kids have had instability for several more years. So I'm not sure that really is an answer to the conundrum that the state is presenting us with.
Well, I think that as the Supreme Court, as the Utah Supreme Court said in JAL, this whole notion that stability can only be achieved by an adoptive placement is overstating the importance of stability. You have on the one hand the importance of stability. You have on the other hand the importance of the child and being raised by its natural family, which even the DCFS agrees is a good idea, if it's possible. And so, if the DCFS agrees that the child will best be served by being raised in its natural family, then that gives the juvenile court a duty and a responsibility to conclude by clear and convincing evidence that being in the natural family is simply not appropriate here. And the evidence, I think the entire record in this case is not a question of sufficiency of the evidence. It's a question of, did the juvenile court look at the right things? It says drugs.
Did one of the judges have a question at this point? Okay. Well, thank you for your time, Ms. Fromer. I'll ask other counsel to join us on screen for the customary little wrap-up comment. which is simply that we appreciate the arguments today. We will, as is our custom, take the matter under advisement and let you have our decision as soon as we're able to get that written in due course.